Ladies and gentlemen, welcome to our discussion today. Our topic for discussion today is how to read the difference between a criminal case and a civil case. In the month of July, I have interacted with 33 individuals. 73% of those individuals showed a burning desire to understand how to read the difference between a criminal case and a civil case. You may also have the same burning desire to understand how to read the difference between a criminal case and a civil case. You are in the right place. I'm going to clear that burning desire. How do we read the difference between a criminal case and a civil case? We use a number of factors to understand the difference between these two cases. In this video, I'm going to focus on 5 factors that we can use to read the difference between these two cases. Factor number 1, the parties. You can tell whether a case is a civil case or a criminal case by looking at the parties. In a criminal case, the parties are the state versus the accused. On the other hand, in the civil case, the parties are the plaintiff and the defendant. The state can also be a party to a civil case. The use of this factor can assist you to tell whether a case is a criminal case or a civil case. Factor number 2, the burden of proof. You can also read the difference between a criminal case and a civil case by looking at the burden of proof required for a party to be successful in its case. In a criminal case, the state is required to prove its case beyond reasonable doubt. On the other hand, in a civil case, the plaintiff is required to prove his or her case on a balance of probability. The burden of proof required in a criminal case is higher than that which is required in the civil case. Factor number 3, the purpose of a case, or the reason why one would file a case, whether a criminal case or a civil case. You can tell whether a case is a civil case or a criminal case by looking at the purpose of that particular case. The purpose of a criminal case is to punish the person who has been charged with a crime. In other words, the criminal case is aimed at punishing the convicted person by either sending the person to prison or requiring the person to pay a fine or requiring the person to perform a community service. On the other hand, the purpose of a civil case is to compensate the injured party or the wronged party. So in other words, the purpose of a civil case is to pay financial damage to the wronged party or the injured party. Factor number 4, the role players. You can tell whether a case is a criminal case or a civil case by looking at the role players. In a civil case, the role players are the parties, that is the plaintiff and the defendant, and their lawyers. The lawyers may be attorneys or advocates. On the other hand, in a criminal case, The role players are the state represented by the prosecutors and the accused, who may be represented by his attorney or advocate. In both of these cases, the presiding officers will be the magistrate or the judges, depending on the nature of the case. Factor number 5, the procedural law to be applied. You can tell whether a case is a civil case or a criminal case by looking at the procedural law that is being applied. In a criminal case, the procedural law that is applicable is the criminal procedure law. While in a civil case, the law that is applicable is the law of procedure, law of civil procedure. In both of these cases, the law of evidence is applicable. I hope your burning desire to understand the difference between a civil case and a criminal case has been cleared. If it hasn't been cleared, I encourage you to send me an email. The email is on my about section on this platform. You can email me with your case so that I can interpret it for you to tell you whether it's a criminal case or a civil case. If the video was interesting to you, you may consider subscribing to my channel. Thank you so much for watching.